Hello and welcome everyone. My name is Lorraine McCord and I'm delighted to have with me today Mr. Scott Lowden, and he is an international trade attorney. He has a background in international trade law, working for multinational companies, as well as a degree from Harvard and a Fulbright scholar. He's here today to talk a little bit about the import process, and he's the author of this book, Import Transactions and Customs Compliance. This is the book that we're going to be using for this class, so I'm delighted that he's local and was able to take some time to stop in and join us. So, welcome, Scott.
Thank you very much.
So, I wanted to start off by asking you kind of what was the impetus and what made you decide to write a book about imports of all things. So.
Okay, well, first I want to thank Richland College because this was the first academic institution to buy my book. And Professor K. Morrell actually ordered it before it was published.
Wow.
And we met before the thing was published, so I feel very close to Richland College. Another thing is that I live close to Richland College, which made it easy to get here. I'm
Awesome.
about a mile from this campus.
Okay, great.
Impetus for writing the book is that I've been a transactional lawyer all my life, and I've been involved in cross-border transactions, but for the last 15 years I got more into exporting and importing.
Mm-hmm.
And that's a very specific discipline that I always avoided while I was doing these transactions because it seemed like a black hole, horribly difficult, and frankly it is. The reason I wrote the book, though, is because when I finally became familiar enough with it, I realized that there was a lack of documentation or documented materials produced by any lawyers on the subject, and you simply couldn't get a reference book that pulled everything together that the typical importer who's wanting to comply with not only with the compliance laws, but with transactional issues that arise to refer to. So I wrote the book. It's the only book of its kind, and I think there's a real need for it.
Okay, great. So I wanted to kind of start off, since you talked about there wasn't a book out there, and as we were discussing earlier, my background comes from working with smaller businesses or new or first-time importers and trying to get them ready for what to expect. And while there's a ton of information on exporting, there's not, as you say, a lot of information on the import side and how to get started. So based on your experience in dealing with the law and dealing with transactions, what are some of the things that you would caution a first-time importer to think about? Putting yourself in the shoes of a small first-time importer that doesn't have a large, multinational firm supporting them, and they've decided that importing is something that they want to do. What advice would you give to them?
Yeah, well, the small importer is addressed in the book. I tried to make this book equally available for the large company or for the small importer. There are differences between the two.
Sure.
And if you're talking about advice to the first-time importer who's not likely to be terribly large,
Sure.
I would nevertheless say the same thing to him as I would say to a large company, and that's importing strategy really is to control the transaction that you're getting into with the seller or with any of the intermediaries, like brokers and freight forwarders and bankers and all the other people that you deal with in consummating a transaction. The advantage you've got, even when you're small, is that you're a buyer. And just like a shopper who goes into a store, you expect to be, get a certain amount of deference because the seller wants your money.
Sure.
Consequently, you do start off with something of a competitive advantage, and the way that I think you need to use that as a first-time importer is to pay a tremendous amount of attention to your purchase order, terms and conditions, because those are the terms and conditions that you have to live by over and over again as you import the products. It's principally done through contracts. The only way you can control a transaction really as an importer is to use your terms and conditions of your purchase order. You're the guy who writes the purchase order. You're ordering something. You attach your terms and conditions of the purchase order to the order, and you hope that the supplier that you're going to is going to simply sign off and buy on your terms and conditions. If you do that, and if you've produced a very good set of terms and conditions that keep you protected and even enhance your compliance, you're well ahead of the game. If you're a smaller, low volume importer, like a lot of first-time importers are going to be, I also have to recognize that your bargaining position is not what it would be if you were large and the seller were very eager to deal with you. And in some cases, the seller's not particularly eager to deal
Sure.
with you, and you got to deal with that circumstance too. That being the case, the seller may just say, well, your terms and conditions of your purchase order are very nice and well written. However, we have our own terms and conditions, and if you want to buy our product, those are the terms and conditions that you're going to have to sign off to. When that happens, I'm not going to tell an importer to get out of the business because they didn't follow his rules. But what the importer needs to do in that case is to pay a lot of attention to what he's signed up to. You certainly can find things in sales contracts that you can't live up to and should not live up to. And in some cases it might be a deal killer, but in most cases it's not. In most cases they'll change it. One more thing. That's the transactional part. For compliance, the first-time importer, it's extremely important that he finds a good customs broker.
Okay.
The customs broker is your agent. He represents you in all of the compliance matters dealing with customs. He does the entry documentation, and he does a lot of the other documentation, including bank documents and stuff like that. You want a good one and one that you can rely on, particularly if you don't have a whole legal department ready, sitting there, or a compliance director ready to deal with these things. On the other hand, that does not let you off the hook. Unfortunately, under the law, the importer is responsible for any of the mistakes that are made by a broker acting in his behalf, even though the broker is acting in his behalf. That's a law that changed back in the, I think, early 90s. Consequently, you're always on the hook, so no matter how good your broker is, you've got to pay attention to what he's doing, and you can't blindly rely on him.
So how does, we talked about the need for a broker and how they have some negotiation. They may have some, wiggle room to negotiate and dictate terms even as a smaller importer. But as a lawyer necessary to this process do you think?
Well, you want to save money, so you don't want to pay a whole lot of money to a lawyer. There's one place where I would use a lawyer, and that is the initial documentation that you produce, because every item, every time you make a transaction, you're going to be sending out your terms and conditions. Those terms and conditions should be written by and vetted by a lawyer.
Okay.
No one else but a lawyer, in my opinion, because that's what they're trained to do. A lot of lawyers don't know how to do that very well, so don't let them, pull out boilerplate or something like that.
Sure.
You need to tailor it to your particular deal. But that's how I'd use a lawyer initially.
Okay.
And then the other place to use the lawyer is when you're in trouble.
Sure.
We'll get to that.
Sure, absolutely. But something you said made me curious. How would you categorize a transaction? You talked about having that purchase order as a start or a beginning of the transaction for importing, but would you mind tracing that sort of transaction to where you see its conclusion of, maybe clearing customs or receiving your goods?
Yeah, the purchase order is basically the terms and conditions that you impose on your supplier for purchasing, purchasing your goods, and the terms on which the supplier provides or does not provide transportation from its place to yours. In between that transaction, there's a transaction with the carrier. Often it's an ocean carrier because most imports come by ocean transport. Consequently, that's another transaction. Some Some importers want the exporting company, the supplier, to do everything. That may or may not make sense. You just have to look at it in your own individual circumstances. In most cases, you really want to handle the importing part yourself. So you look at the INCO. I don't want to get too technical
You don't want
here,
DDP INCO terms.
you don't
is
want
what you're saying.
DDP INCO terms unless you own your supplier and it's not an arm's length transaction.
Okay.
But INCO terms are an important ingredient of the purchase order terms. They're just one
Sure.
of many. Warranties, all kinds of things that you're going to have in your purchase order contract. But so you may be dealing with a carrier. If you deal with a carrier, you have no hope of making any improvements on their contracts. They simply won't they won't transport your stuff unless you sign up to the terms and conditions on their bill of lading.
Okay.
The book's going to explain to you what do those terms and conditions look like, what you have to look out for. And the way you plug that gap is by your insurance, your carriage insurance.
And you made some good points, speaking of insurance, about the need for insurance and what they don't cover, and some of the things being below, some of the containers being below deck versus above deck and that kind of thing. Do you want to talk about that? I found it really interesting. I mean,
well, things have changed in the transportation industry, and if you look at the cover of this book, you can see what happened with this container transporter. It hit a reef, and probably looks like 2/3 of its cargo is above deck. Well, look what happens. I mean, they're falling into the water. There's all kinds of strange stuff that can happen. So insurance needs to contemplate who's responsible for on-deck carriage, and there's often a fight that goes on between the carrier and the insurer over liability. The carriers exempt themselves from every conceivable liability. Even this. I don't know if you can see this, but this was a pretty rough transport by the Rena off the coast of New Zealand, and that captain, as I understand it, went to jail in New Zealand because he wasn't supposed to hit the reefs. Anyway,
Sure.
I could go on about that, but yeah, insurance is intimately related to the amount of potential liability you have because of the carriage, the bill of lading terms and conditions that the carrier provides.
Okay.
And they're almost always the same. They come out of a trade association that the carriers belong to.
Okay, so we talked about the purchase order, we talked about the need for cargo insurance, because you're going to be dealing with the carrier. Who else might a typical importer be dealing with in the course of this transaction?
That's a good question. A key one is the broker, which I had already mentioned.
Sure.
When you sign up with a broker, you are giving that broker agency power to act in your behalf. First, when you do that, you need to be careful that you're not giving too much authority to a broker to act on your behalf. There's two types of contracts that you can have with, powers of attorney, they call them, with a customs broker. One is general and the other one is special. You want special. General power of attorney literally gives the broker the legal ability in the contract to act in your behalf on any matter, anything, which is just nonsense.
Now, is that the form 5291 from Customs?
I can't remember if 5291 was the general form. It might very well be. It's mentioned in the book, but there's two types of forms. One's short that the Customs puts out.
Yeah.
So you don't have to slavishly follow that.
Oh, okay.
The other one's the special one that everybody else uses, and customs brokers aren't going to insist. They don't really want that kind of authority anyway. So just make sure you don't sign the short form. You sign the long form.
Okay.
That's one thing. The other thing is you have to look out for the terms and conditions that come behind those powers of attorney, and those are the long ones. Same as the carrier's bill of lading. There's a whole bunch of stuff, in the small print and everything that the carrier has on the bill of lading, on the back of the bill of lading, called the terms and conditions, and so is the broker. And the book actually will specifically give you examples of things that are unreasonable in the typical broker form, even if it's a a special power of attorney, so you need to look out for those.
Okay, great. So we've covered the purchase order, the cargo, the customs broker. Is there anyone else in?
Well, you
transaction?
have banks and letters of credit, and you know it's quite possible, especially if you're small
Okay.
importer, that your supplier will want to have a letter of credit because they don't quite trust your credit, and the bank will take that right off your hands. It's not a bad way to do business,
Sure.
actually.
Sure. Now, one of the things that the book focuses on, which is important, is dealing with U.S. Customs and all of the rules and responsibilities that are on the importer of record. So, do you want to talk a little bit about some of those? I mean, we
Sure.
don't have the weeks to cover all the things that
Right.
the importer is responsible for, but what are some of the basic things that Customs holds the importer of record responsible for?
Well, the book's actually divided into two parts. Import transactions is the first part, that's part one, and part two is called customs compliance. And part two is about 2/3 of the volume of the book because it's so complicated. When you're dealing with compliance with customs regulations, first of all, as I said, you're relying on to some extent on your broker, but you should never blindly rely on your broker.
Sure.
You simply get a good broker, hope that the broker does a good job. The fact is, everybody violates customs regulations, no matter how good they are. They just do. And the reason is that they're so complicated and they're so pervasive, and they have so many requirements. I know you're saying, you're thinking to yourself, what might those most likely be? I'll throw out record keeping. Hardly anybody keeps records in the proper manner. They always have record-keeping violations because they're so extensive and they're so difficult in the ordinary transaction that's conducted. Other things are it's it's a lot of minutia. We talking earlier, you mentioned classification and valuation. And
Sure.
what would you do if you I'm going to anticipate a question.
Go ahead.
What would you do if you said, oh my God, I entered some goods and I classified them incorrectly, or I valued them incorrectly?
And just for purposes, because we haven't talked about classification, that is assigning the correct harmonized code,
Tariff code.
the 10 digits in the United States to the product so that it can be determined the correct duty that needs to be assessed to it. So that's what we mean by classification. And the valuation, obviously, is going to be the value of those goods,
Yeah.
plus some other things that go into that valuation calculation. But we won't get into that here. But so the point being to the question is that if you mess up, there are consequences. So you were saying some of those.
So how do you deal with customs when you mess up?
Yes.
Those two particular items, classification, valuation, and that type of thing, are related to what you write down when you enter when the product enters the territory of the United States and goes through customs. You fill out a form called an entry summary. A summary classifies your goods and actually computes the tariff that's due on them, if there is one, and it values the goods. It's not too hard to make a mistake with either of those. They happen all the time. Customs anticipated that, so in the regulations, it has a provision for a post-entry amendment, a P, that's well known in the customs community and normally can be dealt with without incurring any penalties. You have about a year. Normally, you have a year between entry of the goods into the United States and what the customs calls liquidation of your entry. So for 12 months, if within that period you found a classification or evaluation error, you simply file a post-entry amendment and you pretty well get off the hook. It's a nuisance, but that's just the way it's done. Now, if you have more serious violations, and when I say serious, they aren't necessarily moral turpitude. It's not hard to get nailed for what Customs likes to call fraud, but which is not what your average, idea of fraud is. It's just a mistake that they consider to be negligent, and if it's negligent, then you're likely to be penalized, and often they will refer to it as fraud. It can be negligent, grossly negligent, deliberate. Those are bad. Go to jail for the deliberate stuff if they find that you were deliberately trying to avoid compliance. But those aren't small compliance matters, but they are, again, the regulations have so many requirements that it's not really too hard to run afoul of them. They have a procedure for that too, which most of us lawyers would tend to guide their importers to, and that's prior disclosure, what they call prior disclosure. That's a voluntary disclosure that you made a mistake that may have resulted. You don't have to say it resulted in a fraud. You just say may have resulted in a fraud, and you tell them exactly what it is, and then you you offer up to them the liquidated damages that are applicable to that. If you do that, you can get away often with you voluntarily submit that you made a mistake, and here it is, and we're confessing it, so to speak. The mitigation of the damages that you'd be incurring is very substantial, so it's normally worthwhile. It's not always worthwhile. I do not recommend in every case that one finds a violation or what they think is a violation, that they rush out and file a prior disclosure to customs. That's something you need to always would need to discuss with a lawyer. Got to pay him for that.
Okay, all right. So I want to ask the question, because you've been in this business a while and I know you have many stories. What can you tell me a story or something that happened to one of your previous clients, as they were trying to import, that they kind of messed up and it got them, and you maybe had to help them fix it without sharing any or breaking any attorney-client privilege?
Yeah, that's the thing, is I got to be really careful about that. I do have episodes that I described in the book that led to prior disclosures, and it gives all of the fact issues, and those fact issues did come from real events, although I tried to
But maybe
mix them
even
up.
in the sense of when you're creating a contract with even your supplier, and because one of the things that I know from working with small businesses is that you may have the best written contract, but in some cultures a contract isn't necessarily worth the paper it's written on. So
That's exactly right. That's different though than compliance with customs.
Sure, absolutely.
That's your transactional environment, and I'll go back to the customs one real quick. I'll give you a story, but I want to address what you just said. Big deal is be aware that the jurisdiction in which your dispute with your supplier takes place could be in the country of the supplier, it could be somewhere in between en route, or it can be in the United States. And no matter what your contract says, and we get into that in the book, no matter what your contract says, foreign court looks at it and says, no, I got this case, and I'm not interested in what your contract says. Here's what our civil law requirement is, and you'll have to deal with that. And so you have to anticipate that you may be in a foreign court. One of the alternatives to that is almost every country is signed up to arbitration treaties that would allow you to specify arbitration if you think you're going to get into that kind of a situation. So that might be a route to take rather than always specifying U.S. law of, Dallas County applies and you must litigate in that place. It just isn't that simple.
Okay.
The other thing, there was a lady. This isn't even an import thing, but it's my favorite. It's my favorite story. There was a lady who bought a suitcase. She was traveling to Argentina, and she bought a suitcase from eBay. And the suitcase was unusually heavy, but she didn't think much about it. She just put it away. When the time came to travel to Buenos Aires, she packed it up with her clothes and headed for the airport, and was you know, on her way. She was at the airport, and she was waiting for her plane to arrive, and she got directed over to a private place by some customs officers. And I'll try to make the story short. They found $50,000 in the lining of her luggage. Now, this could happen importing or exporting, because you're supposed to report that.
Yeah.
It's really none of anybody's business that you are carrying money. You have a perfect right to carry it in or out of the country, but you're supposed to report it. And that's a census issue, actually, that's enforced by by customs. So anyway, this you know, she had no idea. She had simply bought the thing on eBay, and as it turns out, when we went out to defend her, and I loved this case. This was my baby. We found a lot of mistakes by customs, including evidence that they knew that the lining of the suitcase had been stuffed from pictures that they got of it before it was sold on eBay. And we sent copies to customs of the pictures, stuffed with the dollars that customs itself had taken and provided to the client. Long story short, we got her off. It took 2.5 years, and we got all our money. It was her money, and we got it back because it was her suitcase.
Wow.
So I love that story.
Okay. Well, we're coming up to the close of our conversation,
Sure.
So I wanted to close out by asking you, there's students who are taking this course,
Yeah.
and some of them have, varying levels of experience with international trade, from zero to having worked for a corporation in the trade compliance area. So what would you want a student to take away from going through and using this book in the course?
Well, I think, your course is going to be a challenge in one sense, because the book really has too much information to absorb by a student in a one-semester course. So you're going to be, I think, offering it in a way that gives a overall perspective as to what's important and where to go and what to do, or what people do when something bad happens, or to avoid something bad happening. That's basically what the whole book is about. It goes into more detail as to how to do that than any particular importer would need. Lawyer will find it useful occasionally, because I even have forms that they could use. But basically, I think what they should take away from this is a good overall perspective of how import transactions and compliance works. And then the other thing, if they're going to be in a company or be heavily into importing as a job, if that's really, not all of them are.
Sure.
If they're not, they should go to the bookstore and get their secondhand price for this. Otherwise, if you're going to work in this industry, hold on to the book.
Okay.
There are professionals all over the country that have the book, and I've been told, at least, gotten some pretty good feedback that it's a good reference source for them, because otherwise you've got to go into fragmented sources to try to get the right answer to your question.
All right. Well, I appreciate you coming out. I appreciate your conversation, and that's a wrap for us. So I hope that you enjoyed our conversation with our author, Scott Lowden, for Import Transactions and Customs Compliance. Thanks.